Hey friends, it is me, and I'm just knocking one out really quick. There's the bills that we were talking about on the previous show are before the State House today, and we're just going to go to the State House testimony. We had folks from the Cheshire County Democrats, the Reproductive Rights Panel. They're talking about these bills in Concord, giving their testimony today, and there's lots of great ways to give your input, including calling your rep and emailing your rep and that sort of thing. We also pointed folks to an online a way to express your pleasure or displeasure with bills, your up or down vote on bills. We'll get more into that at a little bit later time, but I think we're going to go right to the State House testimony. We'll get right on it. I'm going to kick one out live. We'll watch the stream together. You know what this is. You've seen it before, and hopefully you'll see it again and get something from it. So here we go.
Hear you okay. Yeah.
I'll start over. Dear honorable members of the Judiciary Committee, my name is Amanda Elizabeth Toll and I represent Cheshire 16, the City of Keene at large. I'm here today as the primary sponsor of CACR 18, New Hampshire's Reproductive Liberty Amendment to add constitutional protections for reproductive rights to the New Hampshire State Constitution. The other sponsors of this bill and I firmly believe in reproductive justice, meaning that all people, regardless of race, class, or gender, have the right to make autonomous reproductive decisions and should have the resources and support to do so. This bill was written broadly by speaking to reproductive medical decisions. It covers everything from abortion to forced sterilizations, which have targeted communities of color throughout history. We cannot emphasize enough that reproductive justice should include both abortion justice and the right to have children. My personal story relates deeply to why I am bringing this bill before you today. When I was a teenager, I needed to access abortion care. I had to comply with the parental notification law. Even though my parents are pro-choice, I found it deeply unjust that my parents would not need to be involved in the decision to give birth, yet would have to be involved in my decision to terminate a pregnancy. I thought long and hard about other people in a similar situation to me who came from different homes, where perhaps they would face sheer hostility and would have people trying to dissuade them from doing what was in their best interests. My own abortion story was the beginning of my journey of fighting for bodily autonomy. When I went to Hampshire College, I began to get involved with reproductive rights activism, including working with the Civil Liberties and Public Policy Program and organizing its annual conference from abortion rights to reproductive freedom, transforming the movement for reproductive justice. Through this work, I learned about more stories that widen my view about what reproductive justice is, specifically two that I'll mention today. One was the story of Rosie Jimenez in 1977, post-Roe versus Wade. Jimenez died after she was denied access to an abortion. Unable to afford the cost out of pocket, she was also unable to use Medicaid funds for the legal procedure and was forced to resort to a dangerous abortion that took her life. Rosie's story taught me how intersectional abortion justice is. This is a racial, class, and gender justice issue. The second was the abortion speak out that is part of this annual conference. I heard a Black feminist speaker, Loretta Ross, share her story. Ross had an abortion when she was a teenager, and at 23, she experienced sterilization abuse, and she was rendered sterile with the Dawkins shield. What I learned through hearing these stories was that I, as a privileged white woman who had faced some barriers, had centered my activism primarily on abortion legality. However, my sisters of color, and brothers too, were not only fighting for abortion justice, but also for their right to have children. This was a crossroads. I realized that my activism could just benefit myself and people like me, or I could learn from BIPOC feminists to also fight for the right of all people to have children alongside abortion justice. This is why this bill is specifically written to include all reproductive medical decisions, not just abortion. The fundamental lesson from Rosie's story, Loretta's story, my story, and millions of other pregnant people throughout history is state interference with the right to have or not to have children is state-sanctioned violence. This bill is unique in that it is a constitutional amendment, and constitutional protections for reproductive rights are the gold standard. In addition to the purposefully bold and progressive content of the bill, the fact that it is a constitutional amendment means it is not subject to the governor's veto. It is a lot harder to undo and would mean that we would not need to fight tooth and nail for reproductive freedom each time there is a change in control of the state legislature. Town and city councils would not be able to pass local ordinances infringing on the right to make personal reproductive medical decisions. Vermont, a state that has consistently promoted progressive protections for its constituents, is moving towards constitutional protections of reproductive rights. New Hampshire residents are overwhelmingly pro-reproductive freedom, but their political party might not align with them on this issue. Putting this issue on the ballot as a constitutional amendment will allow residents to directly show support for reproductive rights, an issue of personal liberty that is very important to Granite Staters. This bill should be seen as complementary legislation to other reproductive rights bills this session. Myself and my co-sponsors full-heartedly support the other pieces of reproductive rights legislation being introduced today. I am asking the Judiciary Committee to do justice by Granite Staters and protect their reproductive liberty by voting ought to pass on CACR 18, New Hampshire's Reproductive Liberty Amendment. Constitutional protections for reproductive rights are the gold standard. I also enthusiastically support HB 1674, the Access to Abortion Care Act, and HB 1673 to repeal New Hampshire's abortion ban and ultrasound requirement, which I am a proud co-sponsor. In light of there being many voices in the room to speak on these essential reproductive rights measures, I will be submitting written testimony in favor of the other bills being introduced today. Thank you very much for hearing my testimony.
Thank you. Are there questions? Representative McLean, did you have a question?
Yes, thank you, Mr. Chair, and thank you for taking my question. So, Roe solidifies a woman's right to an abortion, but it also enables states to regulate abortion later in a pregnancy. So, if this bill were to pass, would it trump Roe, and how would that impact New Hampshire's right to regulate relative to the current state? So, for example, would New Hampshire still have the right, for example, to restrict abortion in the 9th month of pregnancy, or would that be lost if this constitutional amendment were to go through?
We have many other speakers who are going to be speaking today, and so they will be addressing some of your questions, so I can defer the questions to the other speakers, and if they're not answered, I can get back to you. I do want to say, this is important, for me as a reproductive justice activist, Roe is meant to be the floor, not the ceiling. So I believe in addition to legality, abortion access is essential, and the right to have children is essential. And my goal as a reproductive justice activist is to build on Roe, not to stop at Roe. Thank you so much.
Thank you.
Are there other questions? Representative Sylvia.
Thank you, Mr. Chairman. Thank you for taking my question. So this bill affects personal reproductive medical decisions. Is it a doctor's personal decision if the state prohibits the doctor from performing abortions?
I want to be very clear, Representative, that doctors and patients should be making reproductive medical decisions, not the New Hampshire State Legislature. That's my position.
Follow up?
Yeah, you can follow up.
But this is a personal right of the person who is pregnant, and the state has licensing capabilities over doctors. Does this interfere with the state's administration of doctors' licensing?
I do not believe it does. Thank you. I believe this, I believe this piece of legislation empowers doctors to do what's best for their patients. I believe that the attacks that we've seen in this legislative body have harmed medical professionals to provide the care that is best for their patients. And overwhelmingly in this state, medical professionals have come out in opposition to all the attacks on reproductive freedom that this legislature has passed. And they are supportive, overwhelmingly, of the 3 proactive pieces of legislation being proposed today to protect reproductive rights.
Representative Nodder, did you have a question?
Thank you, Mr. Chairman, and thank you for taking the question, Representative. Are you aware that in the state of New Hampshire, abortionists do not have to be licensed?
Representative Nodder, I think that question does not directly relate to this. This is protecting the state from interfering with the right of reproductive rights. This is a bill about liberty, and it is going to provide protections for people to make the choice to terminate a pregnancy if that's what they want to do, and to have children if they want to do. It is a protective piece of legislation for patients and providers.
Representative Nodder, did you want to follow up?
Yes, thank you, Mr. Chairman. You had mentioned in your comments that the decision is between the doctor and the patient, but we don't know that the abortionists in New Hampshire are doctors because they don't need to be licensed, which is why I asked.
Ultimately, medical professionals and their patients, the state of New Hampshire, politicians, you should not be interfering with this what I believe is a basic human right. People cannot control their lives if they cannot control their fertility.
Representative Horrigan.
Thank you very much, Mr. Chair. First of all, I would be extremely surprised if just anyone can perform an abortion in New Hampshire. I'd never heard that claim before. And would this this is the same phrase that's used in the U.S. Constitution in the Second Amendment, and certainly there are some regulations on guns, in spite of what some people think. That doesn't say that anybody can take a gun just anywhere. So likewise, if we pass this, wouldn't we still be able to have certain regulations, like it probably would be reasonable to require abortions to be performed by a licensed medical professional, which I believe is the law now anyway?
Absolutely, Representative Horgan.
Yep, so thank you.
Other questions? Representative McLean, you have another question?
Yeah, thank you, Mr. Chair, and thank you for taking my question. I'm just wondering, are you aware of any other states that have incorporated this kind of thing into their constitutions?
Vermont is moving towards it, and I believe it is very likely they will be the first state, and it is our job as politicians to plant seeds for what is good, what is going to give our constituents the most protections, the most freedom to value their civil liberties, to value gender justice, to value racial justice. And even if something cannot pass right now, and I hope it does, if we don't plant seeds for it, it will never be possible. Things never seem possible until they are done. 50 years ago, did gay marriage seem possible? Absolutely not. But myself and my co-sponsors, we know that we're going to be on the right side of history. And those of you who are trying to infringe on people's human rights, the sanctity of the right, whether or not to have a child, something that impacts people's physical, psychological, and spiritual well-being, you will not be on the right side of history.
Other questions? Representative Wolper.
Thank you, Mr. Speaker. Thank you for taking my question. The bill says shall not... I don't turn my microphone on or off.
So just speak up as loud as you can, Representative Wolper, if you would. We're using the microphone to the extent it communicates.
So the language here includes the word inconvenience, which is much stronger than any other language in any constitution I've seen. Can you explain what inconvenience means in relation to not regulating?
Inconvenience. Mandatory ultrasound requirements are inconveniences, in my opinion. Parental notification laws are inconveniences. Mandatory waiting periods are inconveniences. All of these things, these reactionary right-wing attacks that we've seen throughout the country to chip away at reproductive rights, they're impeding access. And so I'm not interested in just promoting legality. Legality is essential. Roe is essential. I want to uphold the sanctity of that, but I want to build on it because it is not enough. Rosie's story speaks to that. It wasn't enough. We have too many people. What is a legal right if you can't access that right? And so I believe these access barriers are also state-sanctioned violence. And I want to say we have a lot of people speaking, so I can continue to take some questions, but some of your questions may be answered by our other speakers.
Do we have other questions? I just have one question, and that is looking at the language that's proposed for the Constitution. It says the right to make personal reproductive medical decisions is inviolate and fundamental to the human condition.
It is.
And the question is, who will, and you've explained what you intend that to mean, but when this goes in the Constitution, there's no definition of what that is. And so who will ultimately decide what that means?
So this opens the door. This is going to help pave the way for reproductive rights in New Hampshire. Then, if the state chips away, it's going to be challenged. Because you're going to have, the onus is going to be on the state to prove that they're not unduly inconveniencing. And so my hope is that the state really listens, because constituents support this. Overwhelmingly, in polls after polls, Granite Staters say that they support reproductive rights. And so if you're going to get in the way of that, which you have, we're going to keep challenging it.
Okay, so if I could just follow up on my question, then, as I understand your response is ultimately the court will decide what that means, if it's going to be based upon a challenge.
The courts will decide ultimately, but this opens the door for New Hampshire residents to challenge
Thank you.
those access barriers.
Any other questions for Ms. Toll? Representative Toll, excuse me. Seeing none, thank you for your testimony today. Representative Altschulze?
Thank you very much.
Good morning. I have passed my written testimony up to the front. And I have my notes here, so morning. In November of 2018, 81% of New Hampshire's voters approved adding 22 more words to our state's constitution. Right to privacy, an individual's right to live free from governmental intrusion in private or personal information, is natural, essential, and inherent. Those 22 words were added as Article 2B. That amendment was about control, and who has it? New Hampshire citizens want control over their private and personal information. Our proposal of CACR 18 would be added as Article 2C, with 31 words which complement Article 2B, and our language, the right to make personal reproductive medical decisions, is inviolate and fundamental to the human condition. Neither the state nor any political subdivision shall infringe upon or unduly inconvenience this right. This amendment, like 2B, is also about control and claiming it unequivocally. This amendment didn't come out of thin air, just like 2B didn't come out of thin air. It has inspiration from current statutes and legislative intent. Let me elaborate. In doing my research, there is another place in New Hampshire law where control over medical decisions are in place. I'd like to share with you the first part of Chapter 137J, titled Written Directives for Adults Without Capacity to Make Medical Decisions. In 137J, the purpose and policy statement: the state of New Hampshire recognizes that individual persons have the right, founded in the autonomy and sanctity of a person, to control the decisions relating to the rendering of their own health care. The New Hampshire legislature amended this chapter 3 times and consistently reiterated the purpose and policy statement. The state of New Hampshire recognizes that its citizens have the right, founded in the autonomy and sanctity of a person, to control the decisions relating to the rendering of their own medical care. And yet, when that New Hampshire citizen is pregnant, their right to control decisions related to their medical care and the privacy of that personal information is thrown away. Pregnancy seems to be the line where constitutional rights are stripped away. Article 1 of the New Hampshire Constitution reads, "All men are born equally free and independent. Therefore, all government of right originates from the people, is founded in consent, and instituted for the general good." There is no caveat in Article 1 that says all men are born equally free and independent, except when pregnant. And yet, the loss of freedom and independence is exactly what happens. In Article 2, all men have certain natural, essential, and inherent rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and, in a word, of seeking and obtaining happiness. Equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin, except when pregnant. A New Hampshire citizen who is pregnant loses the benefit of their life and liberty to the mercy of the state, particularly if their pregnancy is life-threatening or if their pregnancy loses viability. Their rights to seek happiness by making reproductive medical decisions independently, as is their natural right, are stripped away. They no longer have control over their own body. They are enslaved to a law. marginalizing pregnant people by stripping them of their natural, essential, and inherent rights of control over their reproductive medical decisions is not the New Hampshire way. When a person does not have freedom over their reproductive decisions because of state interference, they are chattel. This is not the New Hampshire way. New Hampshire citizens value our natural rights, and it is unjust and undue burden to restrict the reproductive medical decisions made by New Hampshire citizens. It is time. It is time to enshrine our values of freedom of reproductive decisions into our state constitution, because the constitutional protections for reproductive rights are the gold standard. I respectfully ask you to vote ought to pass on CACR 18. Thank you.
Thank you. Are there questions for Representative Altshuler? Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. I'm just sorry, my microphone. I'm just trying to understand a little bit the scope of the phrase unduly inconvenience. Are you aware of anywhere in any other states where that phraseology is used in relation to, reproductive law? I'm just trying to see, has there been a precedent or anything established around that phraseology anywhere?
That phraseology is a New Hampshire original, because that's the New Hampshire way, and we would like to put the questions, because there seem to be enormous questions within our state legislature, while the state electorate does not have the same reservations and questions, that indeed reproductive medical freedom is a natural right, and is not the state's business to make decisions about whether someone should or shouldn't have a child, whether they can or cannot access birth control, whether they should or shouldn't, or at what age they might access a vasectomy, whether they should or shouldn't carry a pregnancy to term, regardless of whether it's life-threatening, whether a pregnancy is something that has to be carried in the event of an incestual rape. All of that is a decision to be made by the person for whom it affects. So I have no business making reproductive decisions about your health any more than you have business making reproductive decisions about mine.
Thank you.
Other questions? I think if I could ask a question.
Certainly.
And it gets to the beginning of your statement and talking about the constitutional amendment with regard to privacy, which
Yes, sir.
was already voted on by the people. And one of the issues with that, particularly with regard to the Judiciary Committee and our experience on the Judiciary Committee, is nobody knows what it means. So I think there's a general sentiment that people want to have privacy, but nobody knows how that applies to their lives. And so the question is, was that constitutional amendment actually meaningful? And I guess that's the question that I would have with regard to this, and that it is so general. The question is, what does it mean? And it gets to the question I think I asked before, is are we just going to allow the court to decide what this means by virtue of cases? Is that the intent?
So the intent of any constitutional amendment, and I would hazard to say the intent when writing the New Hampshire Constitution was to set in place a series of values that with which we value. So, for instance, you referenced my beginning statement, and I did talk about Article 2B, and Article 2 that says all men have certain natural, essential, and inherent rights, among which are the enjoying and defending life and liberty, acquiring and possessing, protecting property, and in a word, of seeking and obtaining happiness. So that is not a prescriptive statement of exactly how to enact that, and it is then, as we know, the responsibility of the citizenry, as outlined in Part 1, that we are to govern ourselves, and that we govern with consent, and with the government originating from us, founded in consent and instituted for the general good. So the Constitution is a value statement, and the legislature and the courts have to dig through the weeds and figure out how that applies. I would hazard to say that also in the Constitution, women are not mentioned. And yet, we are subject to all of the laws of this state. And so there is an interpretation that we should be included. So the interpretation part is our job.
Okay. Thank you. Any other questions? Seeing none, thank you for your testimony today.
Thank you very much for your time.
And we have another co-sponsor, Representative Mcwilliams.
Thank you, Chair. Thank you, colleagues. It's a pleasure to be here. My name is Representative Rebecca Mcwilliams. I represent the west side of Concord. I'm here representing the women of Concord. It's 2022, and we feel empowered and free. And it is the first time that I'm pleased to offer this constitutional amendment for the women of New Hampshire. Just want to tell you a personal story, a little bit about me and reproductive health. I'm a mom of 3, and it has taken great effort to become a mom of 3. I worked really hard and spent a lot of money to have twins 4 years ago and was successful. And immediately after I had those twins, I found myself pregnant again. I wasn't ready to have another child. I didn't know what to do. I prayed about it. My husband and I talked about it long into the night, and it turned out that that pregnancy was not viable. I ended up having an ectopic pregnancy. That could have killed me. And my ability to make the decision to have surgery and end that saved my life. Taking away a woman's decision about what she does when she's pregnant can indeed risk the life of the mother, and in my case, it would have killed me if I could not have had that removed. So I'm down 1 ovary. But I was fortunate enough, with a little bit of help of science, to get pregnant again and have a little girl who's now 1 year old. And I'm very lucky. But that could have gone really badly, and a lot of horrible things could have happened during that high-risk pregnancy because I have high blood pressure. And once again, between myself and my doctor, we had to look into what were the right decisions every month. Every time I had a scan, we had to look into that, and it was between me and my doctor. And so I'm here representing the women of Concord and the women of New Hampshire to let you know that we will make the decisions that we need to make that are right for us and right for our families. And there is no reason for the state to get involved. And so I thank you for your time, and I wish for you to consider that it is 2022 and that women know what we're doing and that we will take care and do the right things. Thank you. I'm happy to take questions.
Any questions for Representative McWilliams? Representative Sylvia.
Thank you, Mr. Chairman. Thank you for taking my question. You mentioned that this is a decision between you and your doctor, and the amendment is a personal decision. It's protecting the personal decision. The doctor is licensed by the state. Do you propose that we should have doctors that are not licensed?
The reason I mentioned myself and my doctor is because I was relying on a medical professional who's been through this thousands of times with other people and who understands where we were in the process and what things looked like. I do not pretend to be a doctor, nor do I play one on television, and so I believe that the right thing to do is confer with a medical professional to make these decisions. But make no mistake, it was not my doctor's decision, it was my decision, and it was informed by what my doctor was telling me throughout the process.
Thank you. Any other questions for the representative? Seeing none, thank you for your testimony today.
Thank you.
We do have another representative. I think that completes all of the sponsors and co-sponsors. So at this point in time, we'll be looking at testimony for 3 minutes. We do have another representative who wishes to speak, and that's Representative Folsom.
Good morning. Thank you, Chairman Gordon and the committee for hearing my testimony today. My name is Beth Folsom and I represent Grafton County District 11. I'm coming before you today not to discuss the morality of the law. There's going to be a lot of people on either side of the issue that will discuss that, and I'm going to leave it to them. What I'm coming before you today to do is to talk about the language that's involved in this law. It is incredibly broad, and it will lead to a large number of unintended consequences. While working in the Colorado State Legislature, this same not exact wording, but really close, came before the legislature. We discussed this, of course, all throughout the Capitol. You can imagine all the little conversations that pop up. And we came up with so many unintended consequences that the sponsor chose to pull the bill before it went to the floor for debate and a vote. And so I'm concerned that if this were to pass, we're going to end up with those unintended consequences here. Some of the issues in the language that are concerning is age. It doesn't talk anything about an age. Is this just someone who is of the age of majority, or is this someone who happens to be 12 years old? There has to be someone involved in that child's life. Hopefully it's a parent who loves them and cares for them, who is helping take them to the doctor, that will be involved in this. A 12-year-old, unless they're incredible, and I know when mine were 12, they would not have made a good decision. That is important to have that parental notification and advice. The second is gender. This doesn't talk anything about gender. And yesterday in this committee, you heard a bill about the father's reproductive rights. I don't think, from how I read the room, I'm not quite sure that that's going to go very far. But all of a sudden, you're leaving room in here for fathers to now sue a woman who has had an abortion because his rights were violated. So that's another thing that needs to be cleaned up. And then also, it doesn't really clarify the intent of, is this just for ending a life or pregnancy, or is this also for being able to get pregnant?
15 seconds.
Okay, I'll just finish this one up. I have more, but so then we run into other problems with that as well that the state has to get involved in. Okay, and so I do not support this bill, and I would ask you to vote ITL.
Any questions for Representative Folsom? Yes, Representative Horrigan?
Yes, and I guess I asked this question of a supporter of this bill, so it might be fair to ask this question of an opponent of the bill. The phrase "shall not be infringed" echoes the Second Amendment, and I suppose there's a lot of disagreement about how much regulation the Second Amendment to the U.S. Constitution applies, but historically hasn't that always been interpreted to mean that the government has at least some leeway to regulate firearms? So wouldn't there be at least some leeway here to regulate abortions, but it would prevent the state of New Hampshire from totally banning them?
Yeah, if this were to pass, and with that word inconvenience and infringe and those kinds of words, basically the Fetal Protection Act, Life Protection Act, could stand in place because it's a reasonable infringement. It's a reasonable alternative. So if they really want to make sure that they have the right to make that decision up to birth, then that's what they should work on, not creating an overall broad category that then all of a sudden we're back in here making the same decision as to how we are going to interpret that piece of legislation.
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. I'm curious what your thoughts are on the last speaker's testimony where she talked about equality except for when you're pregnant. New Hampshire citizens who are pregnant lose their benefits of liberty, life and liberty, particularly if their pregnancy is a life-threatening or pregnancy loses visibility. How do you feel about that? Do you feel that the law, the way it is now, the Constitution is equal for everyone?
Thank you for that question, and I'm going to try and, there's a few parts to that. So, the first part, oh gosh, I'm trying to go back to the first part of your question. I'm going to start with the ectopic pregnancy. That is a risk to the health of the mother. There is no bans in this state, even in the Fetal Life Protection Act. She is allowed to get an abortion if it is going to, as she was afraid, would kill her. Ectopic pregnancies are very, very dangerous. So that would not be stopped by the laws that we have right now. Again, the women in the state do have a right to have an abortion up to the week 24 for any reason whatsoever and any time. We basically just followed what the Supreme Court said at 24 weeks, where you're looking at there's another life involved. So we wanted to protect the second life as well as the life of the mother.
Other questions? Yes, Representative Sylvia.
Thank you, Mr. Chairman. Thank you for taking my question. I want to focus on the unduly inconvenience at this point. Would it be considered unduly inconvenient to require a medical professional to be the person performing the procedure that's desired here?
In my own personal opinion, I'm going to give this, and I think being on the Health Human Services Committee, we deal with a lot of these, and plus the licensure board and all of that. If you think about the people who perform other types of invasive procedures on a woman's body or on a man's body, most of them have to be licensed. And so that I would definitely want it to be a person for the safety of the mother and the woman. I would want that person to be licensed and very carefully licensed process go through.
Other questions? Representative Simpson.
Thank you, Mr. Chair, and thank you for taking my question, Representative. I was looking at the bill after you mentioned age, and you're right, I don't see age listed anywhere there, but I'm wondering if you can tell me if anyone's age is talked about in other places in the Constitution, in other articles.
I don't think so. I'd have to check with the Constitution specialist, but I do not believe in reading that there is a law regarding age. Maybe someone on here could answer that better, but maybe we shouldn't be the first ones to change that. I mean, I want to say this correctly. By keeping with the language of the Constitution, by not mentioning age in this situation, if this went through, then it would open the door for anyone of any age could receive any type of reproductive procedure.
Thank you.
Other questions? Seeing none, thank you, Representative.
Thank you.
I have a card from Senator Whitley. Senator Whitley here. Tony LaBranch.
Good morning, House Judiciary Committee. For the record, my name is Representative Tony LaBranch, and I represent the town of Amherst. I come before you today to talk about the numbers, not debate anything in the bill. I come before you as a representative of Purple District. Yet it seems that there's one thing the majority of Amherstonians can agree on, and that is reproductive rights are a basic human right. Polls show that the majority of Granite Staters, 66% in 2014, 73% in 2018, and most recently, as Representative Altschiller shared, 83% of Granite Staters agree that the issue of reproductive rights is settled. This CACR simply makes it so that the idea that most Granite Staters agree on, that it is a fundamental human right and that it should be protected, constitutionally protected in that manner. Let the people of New Hampshire have the final say on this matter so that we can finally put this hyper-partisan and divisive issue to rest. That's why I asked the committee to recommend ought to pass. Thank you.
Thank you, Representative. Are there questions? Seeing none, thank you for your testimony. Patrice Myers.
Thank you, ladies and gentlemen of the House.
Got to speak up a little.
Sorry. Just want to make one point on one of the other testimonies. Women are mentioned in the Constitution. At the time it was written, man meant people in general, mankind. That's how they used that term. Thank you. The issue here is it is a constitutional amendment. Another change to a document that has been changed beyond recognition up till now. An amendment cannot be made to the Constitution that opposes that Constitution, and this one does. It flies in the face of right to life, liberty, and the pursuit of happiness. We're talking about the mothers who are pregnant, but we don't talk about what's in her. We talk about having or not having children as if they're property. What about the child who doesn't have any say about how it got there? A definition of life is growth and development, and if I can bring science into it, when a sperm fertilizes an egg, that egg starts to develop and grow. It starts to become a human child, not an elephant, as I saw on the sign outside. Our writers of the Constitution relied upon God. I know I shouldn't mention him, but he doesn't depend upon your belief or unbelief. He is. And the truth doesn't depend upon opinions or perceptions. It is. And the point of the fact is that when you get rid of the life that is in the womb, it is murder, unless, and we do, again, have laws that stipulate if the life of the mother is in danger. Of course not. In terms of rape and all that, that's why we have parents, so that they can guide their children through this. But as a general rule, to snuff out that life that had no say in how it got there is murder. Thou shalt not murder. My last point is, you all make an oath to protect the rights of the Constitution. That includes the rights of everyone, born and unborn, to pursue life, to continue in their development and growth, liberty, a chance to live free from being murdered, and the pursuit of happiness. When you kill an embryo, they have none of that.